All right, so are you ready to unlock the vault of knowledge? Because today, we're diving deep into the world of trusts,
Ooh, sounds exciting.
specifically how to set them up the right way, so
Right.
they really do what you intend them to do.
Yeah, and that's the key, isn't it? Because it's easy to think of trusts as something only for the super rich use,
Right.
but in reality, they can be really powerful tools for anyone looking to manage assets,
Absolutely.
whether it's for family, charitable giving, or even safeguarding a valuable collection, something like that.
You've hit the nail on the head. That's why this deep dive is so important.
Hmm.
We want to equip you, the listener, with the knowledge to make informed decisions.
Right.
Whether you're thinking about a trust for your family's future, a favorite charity, or even, that collection of rare comic books you've been putting together.
Absolutely. And a good place to start is understanding that not everyone can just create a trust.
Oh, okay.
There are certain legal requirements, and one of the most fundamental is the concept of capacity.
Capacity. Okay, that sounds like a pretty crucial piece of the puzzle. What does capacity actually mean in the context of trusts?
Well, essentially, it boils down to the legal ability to understand what you're doing when you create a trust. You need to be able to grasp the implications of your decisions, both for yourself and for the beneficiaries.
That makes me wonder, how does the law handle situations where someone might not fully understand those implications? Are there safeguards in place?
Absolutely. The law recognizes that capacity can be tricky, especially when dealing with children or individuals who might lack mental capacity for various reasons.
So there are special rules in place for those situations.
Exactly. Let's take children, for example.
Okay.
Any trust a minor tries to create is considered voidable. That means they have the right to back out of it once they reach the age of majority,
Yeah.
18,
Okay.
or within a reasonable time
Okay.
afterward.
That makes sense. Protects them from making decisions they might regret later on when they have a more mature understanding of the implications. What about individuals who might lack mental capacity? Is it a blanket rule there too?
It's a bit more nuanced in those cases. The court looks at each situation individually,
Okay.
taking into account factors like the complexity of the trust and the value of the assets involved.
So it's not as simple as saying yes or no to capacity. It's all about the specifics of the situation.
Precisely. And that's why getting legal advice is absolutely essential, especially in these more complex situations.
Yeah.
A qualified professional can help assess capacity and ensure the trust is set up in a way that protects everyone's interests.
Solid advice. Now let's talk about the actual nuts and bolts of creating a trust. We often hear about trusts for personality, but what does that even mean?
Well, think of personality as everything that's not land. It encompasses things like money, investments, jewelry, vehicles, artwork, even those valuable comic books we mentioned earlier.
Okay, so basically all the cool stuff. What are the rules when it comes to setting up a trust for personality during your lifetime?
Well, here's where things get interesting. Creating an inter vivos trust, that's just the fancy legal term for a trust, created during your lifetime,
Okay.
for personality,
Mm-hmm.
doesn't actually have any formal requirements.
Wait, really? No specific hoops to jump through?
It can be, yes.
That's surprisingly simple.
It can be, yes. But that simplicity for personality trust often highlights a crucial point about the law balancing ease of creation with the need for clarity and enforceability.
Right.
And that's where trusts for land or real property take a different turn.
Okay, I'm sensing a but coming. Why are trusts involving land treated differently? What makes them more complex?
The key difference lies in the fact that land is considered a much more permanent and valuable asset. Because of that, there are stricter rules in place to prevent disputes and ensure that everyone's interests are protected.
So more formality is needed to create a land trust.
Exactly. We need to shift our focus to the Law of Property Act of 1925, specifically Section 53, 1B. This section mandates that any declaration of trust involving land must be evidenced in writing and signed by the person creating the trust, known as the settlor.
So unlike those more casual personality trusts, we need a paper trail for land trusts. No more handshake agreements.
That's right. Having that written evidence is crucial because it helps avoid ambiguity and protects everyone involved. It clearly outlines the terms of the trust, who the beneficiaries are, and how the land should be managed.
Makes perfect sense. Starting to understand why these formalities are so important. It's all about preventing confusion and potential disputes down the road.
Exactly. And here's where things get even more nuanced. The law doesn't actually require the trust itself to be created in writing, just that written proof of its existence must be available.
Okay.
This is often referred to as evidence of the declaration of trust.
So hypothetically speaking, I could declare a land trust out loud, but if I didn't have any written documentation to back it up, it wouldn't hold up in court.
You've got it. The trust wouldn't be automatically void, meaning it wouldn't completely disappear. However, without that written evidence, it would become unenforceable. That's a critical distinction for our listeners to understand.
I'm definitely going to highlight that for everyone listening. Unenforceable doesn't mean the trust vanishes. It just means you can't take legal action to make sure its terms are followed. That's a crucial difference.
Absolutely. It's like having a set of rules that everyone agrees on, but without any way to enforce those rules, they become essentially meaningless in a legal sense.
So written proof is key when it comes to land trusts. What other important points do we need to know about this section of the Law of Property Act?
Well, it also covers something called the disposition of an equitable interest, which might sound a bit technical, but it's really just a fancy way of describing how a beneficiary can transfer or give up their share of the trust property.
Okay, breaking it down like that makes it much clearer. So, what are the rules when a beneficiary wants to get rid of their interest?
This is where Section 531C of the Law of Property Act comes into play, and things get even stricter. This section states that any disposition of an equitable interest must be in writing and signed by the person giving up their share or by their authorized agent.
Wow, okay. So we've gone from no formalities for personality trusts to written evidence for land trusts, and now to even stricter requirements for a beneficiary transferring their interest in land.
Yeah.
It seems like the more valuable the asset and the greater the potential for disputes, the more important those formalities become.
You're absolutely right. It's all about ensuring clarity and preventing future problems.
And what happens if a disposition isn't made in writing? What are the consequences?
In that case, the disposition is considered completely void. It's as if it never happened.
Wow, okay. No room for error there. Can you give us some real-world examples of how this works in practice? I think that would help clarify things for our listeners.
Certainly. Let's say a beneficiary wants to assign their interest in a piece of land to someone else. That means they're essentially transferring their ownership rights. In this scenario, putting it in writing is absolutely non-negotiable.
That makes sense. It's similar to transferring ownership of a car. You need the proper paperwork to make it official. What about if a beneficiary wants to change who benefits from their share but doesn't want to give up their interest entirely?
Right.
Let's say they instruct the trustees to hold their share for the benefit of someone else.
That's still considered a disposition of their interest, even though they're not giving it up completely. So yes, that also needs to be in writing to be legally valid.
Got it. So anytime a beneficiary wants to make changes to who ultimately benefits from their share of the trust property, we need that written documentation. But are there any exceptions to this rule? Are there situations where writing isn't required?
There are a couple of interesting exceptions, and they hinge on some subtle but important distinctions in how trusts operate.
Okay, I'm all ears. This is where it gets really interesting. What are these exceptions?
The first exception involves a beneficiary declaring themselves a trustee of their own interest for someone else.
So they're essentially saying, I'm going to hold on to my share, but I'm going to manage it for this other person's benefit. That's a clever workaround. And in this case, no writing is needed.
That's right. Because they're not actually disposing of their interest, just changing how it's managed, the strict writing requirement doesn't apply.
Fascinating. What's the second exception?
The second exception involves a specific type of trust known as a bear trust.
Okay.
In a bear trust, the beneficiary has a direct and absolute right to the trust property. If a beneficiary under a bear trust instructs the trustees to transfer the legal title, that's basically full ownership, to someone else, no writing is required.
I'm curious, why is that? It seems like we're bypassing that written requirement again.
It all comes down to the nature of a bear trust. When you transfer the legal title in a bear trust, you automatically transfer the beneficial interest along with it. So the person receiving the asset gets full ownership, both legal and beneficial, in one fell swoop.
Uh-huh.
Because there's no separation between those interests, the written disposition rule doesn't apply.
So it's like a package deal. They get everything all at once. That makes sense.
Precisely. But even with these exceptions, it's crucial to remember that trusts can be complex, and the lines aren't always clear-cut. Getting legal advice from an expert who understands the nuances is always the safest course of action.
Couldn't agree more. Now, I know you have a fascinating court case up your sleeve that perfectly illustrates these technicalities, the Vanderbilt case.
Ah, yes.
It involved a generous millionaire, a donation to a prestigious medical institution, and, of course, the ever-present taxman.
Yes.
Can you set the stage for us?
Yes. The Vanderbilt v. IRC case is a classic example of how even the most well-intentioned trust arrangements can run into unexpected legal hurdles.
Mm.
Mr. Vanderbilt, a wealthy businessman, wanted to make a significant donation to the Royal College of Surgeons to establish a chair of pharmacology. To facilitate this, his bank held shares in a family company on his behalf as nominees.
Okay, so this nominee arrangement was essentially a bare trust,
Yes.
where the bank held the legal title to the shares, but Mr. Vandervelde retained full beneficial ownership.
Exactly. Now, here's where things get interesting.
Okay.
Mr. Vandervelde, wanting to avoid certain tax implications, instructed his bank to transfer these shares directly to the college,
Right.
along with an option for his trustee company, Vanderbilt Trustees Ltd., to buy the shares back at a later date for a nominal sum.
It sounds like he was trying to be strategic with his donation, aiming to benefit both the college and potentially his own company in the long run.
That's right. However, this seemingly straightforward plan is where the legal drama begins. The taxman took issue with the arrangement, arguing that the transfer of shares constituted a disposition of Mr. Vanderbilt's equitable interest and therefore should have been in writing according to Section 531C of the Law of Property Act.
Ah, so they were trying to catch him out on a technicality. Did it work? Was Mr. Vandervelde's generous donation in jeopardy because of this missing paperwork?
Well, that's a story for the next part of our deep dive.
I'm on the edge of my seat. We'll definitely need to unpack the rest of this case in our next segment. But for now, let's recap what we've learned so far.
Okay.
We've established that trusts can be incredibly useful tools,
Yeah.
but the devil is in the details.
Absolutely. Capacity is key, formalities matter, and understanding the nuances of different types of trusts is essential.
It sounds like we've only just scratched the surface of this fascinating world.
Yeah.
We'll be back soon to delve deeper into the Vanderbilt case and uncover even more insights into the intricate world of trusts.
Sounds good.
Until then, thanks for listening and happy learning. Welcome back, Trust Explorers. Before we dive back into the dramatic twists and turns of the Vanderbilt case, let's switch gears for a moment and explore another important avenue for creating trusts.
Right.
Testamentary trusts.
That's right. While we've been focusing on trusts established during someone's lifetime, it's equally important to consider trusts that take effect after someone passes away as part of their will.
Yeah.
These are known as testamentary trusts.
So instead of setting up a trust while you're alive, you can essentially weave it into your will to ensure certain assets are managed and distributed according to your wishes after you're gone.
Exactly.
What are some key differences our listeners should be aware of when it comes to these testamentary trusts?
One of the most significant distinctions lies in the governing law.
Okay.
While the trusts we've discussed so far fall under the Law of Property Act 1925, testamentary trusts are governed by a different set of rules outlined in the Wills Act 1837, as amended.
Ah, so we're entering a whole new legal landscape.
Yes.
Does that mean things get even more complicated when dealing with testamentary trusts?
Not necessarily. The Wills Act actually lays out a pretty clear roadmap for creating a valid testamentary trust.
Okay, that's reassuring. I'm all about clarity when it comes to these legal matters. What are some of the key requirements we need to keep in mind?
The foundation of any testamentary trust is, of course, the will itself.
Right.
The will must be in writing,
Okay.
clearly outlining the terms of the trust, including who the beneficiaries are, what assets are involved, and how those assets should be managed.
That makes perfect sense. We need a tangible record of those wishes, just like we discussed with trusts for land. What else?
Well, just like with other legal documents, signatures are crucial.
Okay.
The person making the will, known as the testator, must sign the document or have someone sign it on their behalf, in their presence and under their direction.
So even if someone is physically unable to sign their name, they can still ensure their wishes are captured and legally recognized.
Exactly. It's all about honoring the testator's intent. That signature, or the act of someone signing on their behalf, is a powerful symbol, signifying their desire to give legal effect to the contents of the will.
It's like that signature transforms a simple document into a legally binding expression of their wishes.
Precisely. But the testator's signature isn't the only one that matters.
Okay.
The Wills Act also requires the presence and participation of witnesses.
Witnesses, like at a wedding. Why are witnesses necessary when creating a will?
Witnesses play a crucial role in ensuring the validity of the will. Their presence helps prevent claims of fraud, coercion, or undue influence. Essentially, they serve as independent verifiers, confirming that the testator was of sound mind and acting freely when they sign the will.
It's like having neutral observers to ensure everything is above board.
Right.
How many witnesses are required?
The Wills Act mandates the presence of at least two witnesses
Okay.
present at the same time
Okay.
for the will to be valid.
Yeah.
The testator must sign or acknowledge their signature in the presence of these two witnesses.
So there's a specific choreography involved. Everyone needs to sign in the right order and in each other's presence.
That's a great way to put it. It might seem like a lot of steps, but these formalities serve a vital purpose. They safeguard the testator's wishes and provide a clear legal framework for how their assets should be distributed after they pass away.
These safeguards make perfect sense, especially when dealing with something as sensitive and potentially contentious as a will.
Right.
So, to recap, we have two main avenues for creating trusts. Inter vivos trusts, established during someone's lifetime, and testamentary trusts, created as part of a will. What are some of the key takeaways our listeners should remember as they consider these options?
I think one of the most important takeaways is that formalities matter, regardless of which path you choose.
Yeah.
Whether you're establishing a trust for personal assets, land, or as part of your will, there are specific legal requirements that must be met to ensure its validity and enforceability.
Absolutely. Skipping those steps or trying to take shortcuts can lead to unintended consequences down the road, potentially undermining the very purpose of the trust.
Another crucial point to remember is that the type of trust and the assets involved will dictate which rules and regulations apply.
Right.
As we've discussed, trusts for land has stricter requirements than trusts for personality, and testamentary trusts operate under an entirely different legal framework.
It's like a choose-your-own-adventure for legal formalities. You have to follow the right path based on your specific circumstances and goals.
That's a fantastic analogy.
Yeah.
And speaking of paths, we haven't quite reached the end of our journey into the world of trusts.
Right.
There's still more twists and turns to navigate, more insights to uncover.
Okay.
Remember that cliffhanger we left our listeners with? The Vanderbilt case?
Yes.
It's time to return to that intriguing legal battle and see how it all unfolds.
Yes. Let's rewind back to Mr. Vanderbilt, his generous donation, and that looming question about the buyback option on those shares. The tax man was lurking in the shadows, sensing an opportunity to pounce. What happened next?
Well, remember how Mr. Vanderbilt's trustee company, Vanderbilt Trustees Ltd., held that buyback option?
Yes.
This is where things get really interesting and a bit tricky.
Okay.
The court ultimately ruled in favor of the taxman on this particular point.
Now that's a twist. I was hoping Mr. Vanderbilt would come out on top. Why did the court side with the tax man?
The crux of the issue was that Mr. Vanderbilt, in his attempt to structure the donation in a tax-efficient manner, hadn't clearly specified which of the various trusts managed by Vanderbilt Trustees Ltd. Should benefit from that buyback option.
Okay.
He essentially created a gap in beneficial ownership.
Okay, I'm starting to see the problem. Leaving that gap meant someone had to be designated as the beneficiary of that option, even if it wasn't explicitly stated in the arrangement.
You've hit the nail on the head. The law, especially when it comes to trusts, doesn't like loose ends. Yeah.
Everything needs to be accounted for, every I dotted and every T crossed.
Right.
So the court, faced with this ambiguity, decided that the beneficial interest in the buyback option resulted back to Mr. Vanderbilt himself.
It's like that beneficial interest boomeranged right back to where it started.
Yeah.
Talk about an unintended consequence.
Yes.
So even though he was trying to make a generous donation and potentially benefit his company, he ended up being taxed as if he still owned those shares.
That's the unfortunate reality of this case. It serves as a stark reminder that clarity and precision are paramount when dealing with trusts, especially when complex assets like shares and options are involved.
This case is a real nail-biter. It highlights how even a seemingly minor detail, like not clearly specifying who benefits from a buyback option, can have significant consequences.
What?
What are the key lessons our listeners should take away from Mr. Vanderbilt's experience?
I think the most important takeaway is this. When it comes to trusts, seeking expert legal advice is not optional, it's essential.
Don't try to navigate these complex waters on your own. A qualified professional can help you anticipate potential pitfalls, ensure all the necessary formalities are met, and most importantly, help you achieve your goals in a legally sound and tax-efficient way.
It's like having a seasoned guide leading you through a legal jungle. They know the terrain, can spot those hidden traps, and help you reach your destination safely.
Precisely. And the Vanderbilt case vividly demonstrates why having that expert guidance is so crucial. Even with the best intentions, mistakes can happen. and those mistakes can have costly consequences.
Well, there you have it, folks. Another chapter in the Vanderbilt saga comes to a close. But our exploration of trusts isn't over yet. There's still more to uncover, more insights to glean from this fascinating area of law.
You're right. And in our final segment, we'll step back and consider the bigger picture, the so what of all this information. Why should you, the listener, care about these intricacies of trust law? How can this knowledge empower you to make informed decisions about your own assets and legacy? Stay tuned.
Welcome back, trust enthusiasts. I hope you're ready for the grand finale of our trust adventure, because we're about to unpack the final lessons from the Vanderbilt case.
It's been quite a journey, hasn't it?
And then zoom out to see how all of this applies to you.
Yes, from the basics of capacity and formalities
Right.
to the dramatic twists and turns of a high-stakes legal battle.
Absolutely.
We've covered a lot of ground.
We certainly have. But before we wrap things up, I'm really eager to hear your final thoughts on the Vanderbilt case.
Okay.
You know, it's such a powerful reminder that even with the best intentions,
Right.
things can go awry when dealing with trusts.
You're absolutely right. The Vanderbilt case serves as a cautionary tale, highlighting the importance of foresight and meticulous planning when it comes to trusts.
Exactly. And it underscores why seeking expert legal advice is so crucial.
Absolutely.
You know, a skilled professional can help you navigate those complexities and ensure your trust does what it's supposed to do.
Precisely. Think of it like this. You wouldn't perform surgery on yourself, would you?
Right.
You'd seek out a qualified surgeon with the knowledge and experience to handle such a delicate procedure. Well, creating a trust is, in many ways, just as delicate and requires a similar level of expertise.
That's a great analogy. And speaking of expertise, let's shift our focus to our listeners.
Okay.
We've thrown a lot of information their way. Different types of trusts, legal requirements, potential pitfalls.
Right.
It's a lot to digest.
It is.
So what's the so what of all this? Why should our listeners care about these intricacies of trust law?
That's the million-dollar question, isn't it? And the answer is simple trusts, when used effectively, can be incredibly powerful tools for managing assets, protecting your loved ones, and achieving your long-term financial goals.
They're not just for the super rich or for complex business dealings.
Yeah.
Everyday people can benefit from understanding how trusts work.
Absolutely. Think about it. If you have a family, a trust can be a valuable way to ensure your assets are distributed according to your wishes after you're gone. It can provide for your spouse, support your children's education, or even care for a loved one with special needs.
And it's not just about family. Trusts can also be powerful tools for charitable giving,
Right.
allowing you to support causes you believe in, both during your lifetime and beyond.
Yeah, that's right. And let's not forget about those valuable collections, those rare comic books, vintage cars, or precious heirlooms. A trust can help safeguard those treasures, ensuring they're preserved and enjoyed for generations to come.
So while the legal details might seem daunting at first, understanding the fundamentals of trust law can empower you to make informed decisions about your financial future and legacy. It's about taking control, planning ahead, and ensuring your hard-earned assets are used in a way that aligns with your values and goals.
Exactly. And remember, you don't have to go it alone.
Right.
Seek out a qualified professional who can guide you through the process, answer your questions, and help you create a trust that's tailored to your unique circumstances.
Well said. And that brings us to the end of our deep dive into the fascinating world of trusts. We've covered a lot of ground, from the technical details to the broader implications.
And I hope our listeners have come away from this experience with a newfound appreciation for the power and potential of trusts.
I'm sure they have. So as we wrap things up, here's a final thought for our listeners to ponder. What role could a trust play in your own life? How could it help you achieve your financial goals, protect your loved ones, or support the causes you care about? It's a question worth exploring.
It is.
And who knows, it might just lead you to unlock a world of possibilities. Until next time, happy learning.